Your Honor, today, the witness, in his affidavit and while being questioned in examination in chief and in re-exam, has told this court that they are in control of certain important exhibits which are not within reach of our clients. There's no way you can interfere with those items, exhibits, which are in control of IPOA. Your Honor, the second aspect, which I believe will be addressed by my learned seniors, is the aspect which came out in the affidavit, the issue of forensic analysis. The forensic analysis of the phone, the gadgets, will be done and shall be done in the absence of our clients. IPOA has officers capable of doing that job conclusively without any input from our clients. The attempt by the applicants to say that our clients should be in custody while this process is going on should not be entertained by this court. This court, Your Honor, should abide by the binding decision in Professor Ngugi's decision and release our clients on reasonable bail, which my colleagues have suggested, and put even other conditions which our client is willing and ready to abide by. Those conditions, the discretion is with the court. We therefore submit that the application has fallen short of meeting the threshold set by various decisions cited by my colleague and have been supplied to the court, meeting the requirements of compelling reasons. Finally, Your Honor, the affidavit that was filed before this court I'll allow my seniors to have their time. Thank you.
You know, with the greatest of brevity. Yes. Kanahi. Your Honor, whereas my good colleagues have examined the veracity of the affidavit at the point, my good colleague, what to call him Dr. Kiton, has laid the legal basis, the premise upon which creates a question with the application before you. I'm just reminded before my good colleague, Mr. Mbeta, submits in its finality to say that the application notice of motion that is before you seeks in prayer A, B, C, D. One, that the matter be had inter partes, which is what is happening right now. It is seeking in prayer B, that the respondent be remanded for 21 days, pending completion of investigations. It prays in prayer C, that the electronic gadget seized from the respondent be subjected to forensic examination. And finally, any further orders that this honorable court may deem fit. I am certain, and it's a position we take, that we have no objection to prayer C. If the so would want to examine the gadget, given the fact that they are already seized and in custody of the gadget, as to whether we oppose or not, we would not control what they intend to do. Principally, what Your Honor is being called upon is to give a continuation of detention of 21 days to complete investigations. We submit, Your Honor, that in the deposition of my good friend, Mr. Jibril, that he has since the last 7 days covered 49% of the would-be investigations. I doubt that he would need 21 days to complete the remainder of the 51% of the investigations. Why am I saying this? the persuasion of my good colleagues that, Your Honor, be minded of the provisions of Section 123 of the Criminal Procedure Code, read as Article 49(1)H, as well as G of the Constitution of Kenya in matters bail, that you be inclined to admit the respondent to a pre-plea bond condition is the positive aspect that we are all taking, and we have no doubt that Your Honor, clothed with wide powers to make such a determined decision on bail bond, would grant. But in the unlikely event that Your Honor is disinclined to grant bail bond as is being prayed, that you consider that the days so requested for 21 days are days which are more than sufficient for them to rely on. We are saying that the custodial detention should not act as a punishment. Given the fact that you've been told the cooperativeness of the respondent and the clear position of the application before you, as well as the affidavit of one Mr. Jibril, which presents before you no evidence that the respondent is a flight risk, no material evidence, as said, is placed before you that the respondent is likely to interfere with any witnesses or investigations as they are ongoing. But most importantly, that their wish to have the respondent not granted bail is premised on his own safety. And we would only ask, is the police saying that they are unable to secure and safeguard the safety and interest of its citizens? In the threshold of that, Your Honor, we plead, like my colleagues have pleaded, that to be inclined to grant the respondent bail bond pending this investigation, and I'm minded that he has been cooperative and no indicator has been placed by the investigators or by way of affidavit that he is likely to become uncooperative moving on forward in this particular investigation. And should in both lean as to whether you grant bail, which we hope you do not, that the days sought for completion of investigation are in excess, Your Honor, and that if they are limited, it would not in any way prejudice the investigations, as nothing would bar the good investigators from making a return to this court and seek extension of more or further time so to conclude the investigation. As we oppose that application, we plead with Your Honor that you admit the respondent bail bond pending this investigation, and in the event of such disinclinement, Your Honor, be considerate to reduce the number of days that the applicant seeks to hold the respondent in custody. Benignly, we submit, Your Honor.
Okay. Your Honor, I was thinking that